This
right,
conference will now be recorded.
You're ready to go ahead and start the meeting. Thank you.
Okay, thank you very kindly. So the August 12th, 2020 Sexual Misconduct Committee meeting will come to order, please, with the following members present. Mr. Giacalone.
Here.
Ms. Montgomery.
Here.
Myself, Michael Schottenstein. May I please have a motion for approval of the Sexual Misconduct Committee meeting minutes from July 8th, 2020 meeting?
So moved.
Ms. Montgomery. Mr. Giacalone, thanks. All in favor, please.
Aye.
Thanks very kindly. Ms. Luca, do you want to take us through the language that we have before us in terms of the legislative changes that are being proposed?
GoToMeeting challenges. I apologize. Can you hear me okay? I just had to switch screens quickly. Can you hear me?
Bethany, there?
Yes, we can hear you just fine.
Yep.
Okay, you're all frozen for me.
Yeah, your picture's frozen.
Okay, so I'm actually going to turn it over to, I believe, Jill Reardon's going to give us a readout on some of the stakeholder feedback that we received from our stakeholders with respect to the first round of legislation that we discussed. And Jill, you want to take it away and kind of give us that readout of some of the feedback we heard from our external partners?
Sure. Just as a background, we sent this preliminary draft of legislation out to 18 different stakeholders, including some of the Ohio boards and commissions, the Ohio Nursing Board, the Dental Board, the Pharmacy Board. But then we reached out as well to some of the stakeholders who may be unintentionally impacted or intentionally impacted by the changes that we're looking at to make sure that we weren't having any unintentional consequences for them, and to also just get their general feedback. So we also sent them out to the Prosecutors Association. We did get some feedback from them. Generally across the board, we did have some concerns that were expressed around the peer review process. We've heard back from the Attorney General's office. They had some questions around the definition of indictments. We heard from the Butler County Prosecutor's Office. We also sent out to the Ohio Psychiatric Physicians, the Ohio Osteopathic Association, the Academy of Medicine in Cleveland and Northern Ohio, the Columbus Medical Association Foundation, the Ohio chapter of the American Academy of Pediatrics, the OSMA, the Ohio State Medical Association, and we did get comments back from them, and one of the comments was around the peer review process. We also sent them out to the Ohio Academy of Family Physicians, Ohio Foot and Ankle Medical Association, Ohio chapter of American College of Emergency Physicians. So while we're still getting responses, what we have received, and I have sent to our legal area and to Stephanie as well, have been well thought out and helpful. They all realize this is preliminary and that we're going to take their concerns and questions and meet with them and continue to work on this through the next few weeks. And then Kim or Nate, I think you were going to actually walk through the legislation.
Yeah, so if anybody has any questions about some of the feedback that received, and then I think next on the agenda, we were actually going to walk through our first proposal on talking through changes to the F5. But I think before we move on to that, does anybody have any questions about any of the stakeholder feedback that we received? Okay, so I think we will, I mean, great that we heard from so many participants, and we'll do the same after we get drafts approved by all of you for F5. But Kim and Nate, if you want to maybe just get started on the conversation about some of about what we need to do next with changing F5. if
All right, thank you. You have a memo from me in your packet, we are having our first conversation about the recommendations from the Strauss Working Group regarding the board's confidentiality statute. And you also have in your packet the current version of just that section F5, so you can look at that. So there were 3 recommendations from the working group. One is to create new language that would permit the board or a designated member to authorize the release of investigative information subject to appropriate redaction for good cause, specifically including upon a request for a request from a law enforcement agency. The second is to create new language to allow the president of the board or a designated member to authorize the release of an investigation subject to appropriate redaction when, in his or her professional judgment, disclosure of such information would avert or minimize a threat to public health and safety. And then the third is to amend the confidentiality statute to place a time limit on confidentiality, or at the least, the confidentiality reserved to the board's investigation materials. Confidentiality would be continued for the protection of patient and other information that is confidential, regardless of its inclusion in an investigation. This limit on confidentiality may include a provision to make the report of investigation available once formal action is taken against a licensee. Those are 3 pretty substantial changes. And so as I started working through them, I think there are some questions that I would like to get some feedback from the committee. And my lights just went out. First, we'll talk about, I'll call these the good cause exception, the public safety threat exception, and then the time limit. So first I'd like to talk about the good cause exception. And I did provide for you information from the Board of Pharmacy, who does have language in their confidentiality statute about good cause. And you can see that there. It's very straightforward, and just indicates that the board may, for good cause shown, disclose or authorize disclosure of information gathered pursuant to an investigation. And so some of the questions that I have for the committee would be, if we develop language for a good cause exception, who would make that determination? Today, we do give up information to law enforcement and to other state agencies in our state and other states, and that determination is made by a board attorney. So there's not board member approval on that. It happens in the investigation process, and then it also happens afterwards when our investigation is closed. If law enforcement or the FBI or other entities, the Board of Pharmacy contacts us and they want our investigation, we do a review, we redact things that are otherwise confidential, like attorney-client privileged information or, social security numbers, things like that, and then we give that out. But that is done, through an attorney review. So that's one question that I would have. When we have, you've had 2 instances where you've made a determination to waive your confidentiality, one in the Strauss matter and then one in the project matter recently with some litigation. And that determination was made by the full board. And so the recommendation is to designate a board member. So I guess that's one question that I'd like to talk about. If you're having a good cause exception, who do you want to make that decision? Very good. Dr. Schottenstein.
How we've had these couple of examples where we've waived our F5. Don't we already then have the ability to essentially make an exception for good cause right now? In other words, couldn't the board essentially have a vote to, make that exception without having to have additional legislation?
You certainly have done that, and and the other thing I would say is we also already have the ability to share with a law enforcement agency, and we do that very frequently. So we do already have that, and we have already established that the board can waive its own confidentiality, and I think that comes to us through case law, for that particular ability.
We were in the Strauss matter. I think this is precipitated because of the Strauss matter. There was a issue of interpretation, and I thought a very narrow interpretation, personally. So I think we need to clarify. I think there is existing abilities. Obviously, we've demonstrated that, but if we took a black eye because we hung up on releasing it in another investigation that had been farmed out to Ohio State had hired folks to do the investigation, and we were saying something about it being the issue of agency or it having been farmed out, we weren't able to do that. So if we're going to continue to look that narrowly, then we're going to have to clarify the statute, because we took a black eye and ultimately gave them the information. So if our interpretation it was and continues to be, look, if another investigative partner is investigating but hired somebody to do the investigation and we're not going to release it to them, then we have to clarify that. So that's my only concern. There's no need for us to take the kind of black eye we took and then ultimately give up the information anyway.
So, Kim, to Betty's point, the good cause exception would allow us to vote to release information for good cause to a non-F5 party. In other words, that's sort of what we're getting at.
I think it would. I think the other thing, and this kind of goes into the additional questions that I have on this, because I think one issue in the Strauss case was certainly what can the entities do with it once we give it to them. So the way the statute is written now, we can turn over information to the properly identified entities, law enforcement, other state agencies, other agencies in other states. But it has to be governmental. But when we give it to them, they're required to keep it confidential, as we are required to keep it confidential. And that definitely became an issue in the Strauss matter. I think that's an issue for you to consider, though, that if we're giving the information with no limits, then there is, we don't have control over how that is used. The way the statute's written now, we give the information, but it remains confidential. So I think those are some things to consider.
Okay, I'm going to clarify. We turned it over, and our argument first was that I believe that the contracted law firm that was doing the investigation for Ohio State was not governmental, because the way we defined it was that they were not covered. The employed folks that were doing the investigation, the law firm, was not covered as governmental under the umbrella of Ohio State. Now,
So
if that's how we're going
to clarify, we gave the information to Ohio State, and we gave the information to Ohio State's special counsel appointed by the Attorney General. We did not give the information to Perkins Coie, which was an entity hired by Porter Wright, who is special counsel. but we did give the information to Ohio State and to the special counsel from
We objected to that last entity
we
getting
did,
the information. And so what I'm saying is that we either have to clarify in the statute that these folks are covered by the umbrella of Ohio State being the governmental entity, and the restrictions surrounding this statute, this rule and statute, follow that contractual relationship, or we have to clarify the statute. I don't think we got into an argument over something that was elevating, in my opinion, form over substance. So either we either clarify it, or we have to decide how we're going to interpret. And if it's still subject to interpretation, that seems to me you need clarification. I.e., entities involved underneath, some language that says entities hired in order to do the investigation are still covered by the responsibilities of the statute. You know what I mean?
Okay, thank you.
Dr. Feibel, you have a question?
Yeah, twofold. One is, wouldn't any entity hired by Ohio State automatically fall under the confidentiality that they're representing Ohio State? They would have to abide by the confidentiality. I would assume that Ohio State has to abide by. I would hope, if they're being hired as a law firm investigating this issue. And secondly, not that it's been mentioned, but I just mentioned so I don't have to talk again. But I think the whole board has to be. This happens so infrequently that I would not feel comfortable giving it to a board designee to decide what is released and what is not. I think it happens so infrequently that we can get together as a board and decide that as a board together. And then the final thing so I don't talk is what I don't know what appropriate means, and I don't know if that's a legal term or if that is open to interpretation.
So appropriate redaction?
Interpretation as well.
Okay, you cut out a little bit. Were you talking about appropriate redaction?
I think that's what. Yeah.
Yeah, the third thing, I don't know if that's a legal term or who decides what appropriate redaction means. Is that you, right. Kim? Is that the board? Is that some legal definition?
I believe the appropriate redaction would be within the statute itself. There are certain individuals whose rights are protected, and that also comes out through the case law. So patients, complainants, the physician, and the board. So
security numbers and any other that kind of identifying information.
Right, that as well. But there are other confidentiality interests. The board is not the only entity that holds confidentiality interests in these investigative materials. So when we have done the full waivers, we have redacted that information, the identity of those other individuals, as well as socials, medical information, things like that as well.
Well, Kim, I think that the use of the board attorneys to determine what's for good cause shown works well. When Dr. Feibel was referring to those moments where there is a debate, then I would agree with Dr. Feibel that perhaps we should have a board conversation and vote. But generally, if it's a routine things, it should be left to you folks. We don't need to tie up the processes. But B, with regard to, there is a conversation, I think you said in the pharmacy board about whether it's to avert or minimize a public safety where something is immediate. And in that instance, I'm assuming that's really rare, but where we really cannot afford to say if there's at that point, we want to clarify in the rule. I think that if there's an immediate issue and it's to avert, it's a public safety or something that we'd allow a designee. And frankly, that still could be the board attorney unless it's, unless for some reason there's a debate and then it should go to the board. But frankly, there may be a time when we don't have the time.
You know, I think that honestly, if we have a situation where we are contemplating releasing confidential information to a non-F5 entity, that should have a board vote. It should have a board vote whether it's for public safety. It should have a board vote whether it's for good cause. We have called emergency meetings before. And I think the right thing is that, this gets voted on. And so really the question before us today is, are we comfortable ever releasing our confidential information to a non-F5 entity? And if we're saying that things like for good cause and for public health and safety are legitimate exceptions that would, make us feel entitled to release that information, then, I think we could support that, but it's with the understanding that we would have a full board vote on the matter. That's sort of how I would proceed, my 2 cents.
Thank you.
That's fine with me as long as we're not, if there are routine, I guess I get down to the question that we get to Ohio State. If it's a routine question, I mean, if we clarify the statute so that a contractor or somebody who's an agent of the covered entity can have that information released, I don't know that we need a board vote. But with regard to everything else, if it doesn't slow down the process, I would agree with you, Dr. Schottenstein. But if it seems to me statutorily, if you wrote into so we don't end up slowing it down or looking intransigent in a normal in an investigation that requires the sharing of information for the public good.
The thing that concerns me about that is that it feels to me like passing the buck. I think we should weigh in. Even if an F5 entity is contemplating sharing information with a non-F5 entity, I think that it's better for us to have like a backstop where we can weigh in on something like that. In a worst case scenario, when time is of the essence, as I say, we can still hold a board meeting on an emergency basis and vote to allow that. I just think it gives us that much more say in the matter, if we leave it like that.
Is that even if we built into the statute the permission that as in the Strauss matter, if we built into the statute language that required the contracted entity of the F5 entity had to abide by all the statutory and regulatory requirements, then you're still saying you want to have a board meeting on that?
No, I think by definition, then what you've got is an F5 entity releasing to another F5 entity, and I think that's fine.
Okay.
But I think anytime
that would be fine with me.
Yeah, I think anytime an F5 entity is going to release to a non-F5, we should be able to weigh in on that. Hi, Bob, you had a question or thought.
Actually, Mark had one before I did. So, Mark.
If you'd be so kind, Mark.
I was just going to say, I think if we release the information to another entity, trying to maintain that confidentiality, I think, is really, really important. I'm worried that victims might be hesitant to come forward to the board if they felt that their information could be released to the public. I just want to make sure we really push hard to maintain confidentiality on any information that's released. And again, I think if the board makes any decisions, or like the board president makes a decision on releasing information, that'd be so strongly vetted by our legal team here at the board, because there could be all sorts of ramifications if something was done improperly that could lead to litigation for the board and other things too for improperly releasing information. So strong legal vetting from the board and then maintaining confidentiality when the information is released, I think would be really important.
Thank you so much. And Bob.
Just a clarifying point, Kim, you said, the Board of Pharmacy has this statute. How do they handle this situation?
I'm not sure. So a couple of things about that. And, I also have invited the other boards to kind of listen in on this conversation because they have statutes that are similar. So I'm sure we'll get more feedback. But I'm not sure that it's used often, and it may be in situations, like with protective orders or, like restraining orders, those sorts of situations. And they did actually have some case law about a year ago on this particular language where a court used this this good cause exception to say that the board couldn't publicize its notice of opportunities for a hearing on their website because they had to go through that good cause exception. So I was not able, that was like a Franklin County common pleas decision, and I haven't been able to determine what happened with it. But that was certainly, kind of an area of concern for the attorneys, that if we add this good cause language, we don't want to have, the opposite, that we're having to go to the board and get approval to publicize things that are clearly public record that we, publicize and make available to the public on our website every day. That was kind of an unintended consequence, I think. So I'll get more information. I don't know where it landed. I think it probably didn't go anywhere, but that was kind of an interesting side note.
Okay. It's a comment, just one follow up. I mean, obviously the language, that's a big deal about I was having to get the good cause exception every time we file a notice for opportunity or something like that. So that definitely need to look into that. But secondly, I mean, how often do we expect this? I mean, again, the case with Strauss was so unique. How often is this going to come up? Realistically, I mean, do we see this as,
hopefully not a lot.
No, but I mean,
it's hard to say. It's hard to say because I would say that, as staff, we spend a lot of time dealing with these requests. We deal with this pretty much every day. We get subpoenas, we get a lot of requests. If we open it up and we could be having requests from other individuals, I just don't know. It's not uncommon for us to get subpoenas in civil actions. And clearly the statute does not permit disclosure in a civil action. So, so we work and do, motions to quash on those. And we've been successful with that. But if we open it up, I have no way of knowing how many requests we could get. I think it's probably pretty common that people want the medical board's records for other things, lawsuits, all kinds of other things, but primarily like other lawsuits.
So, Kim, I agree with you. The whole point is this should be routinized as much as possible because you get it regularly. And that exception, when it comes along, I think the big exception is, do we lose control if it's contracted out? And if we can statutorily tighten that, that'd be great. And then where we get into a really tough situation, I agree with Dr. Schottenstein, we bring it to the board. I guess I would like to know, are there what are the penalties for disclosure? Let's just say we're down the road a little bit and then we're down at SCUI, whatever the name of that law firm was, and they disclosed information inappropriately. What are the ramifications to that entity and to the contracting entity, i.e. Ohio State?
Yeah, there really aren't any. And I mean, there's not an enforcement mechanism.
So do you want to build into the statute some ramifications? So
I think that's a great idea.
So you put curbs around it, and reassure us that our information is being properly handled. I think that's maybe something you might want to consider.
I wonder if that's enforceable, though. In other words, once it's out of our hands, it's out of our hands.
If in fact there's a statute that says X is confidential and Y only has the right to have it, and Z gets it and doesn't, and Y has entities that are permitted to get it, they should be all bound by the same statute.
Mhm.
I think. I think you can draft it in a way. We could find out.
I agree with that. Thank you. That's a good point. I think that'd be something good for us to add in.
So then, Kim, sorry, forgive me. I was just going to say, if we do put some language together for a release of F5 information for good cause or for public safety, you potentially could anticipate an avalanche of requests under those terms, where all of a sudden we're getting lots of requests, and then potentially, conceivably, the reason we're not getting those requests now is because the answer is no. Right now.
Right.
But if there's a possible yes, we could start opening the door to lots of requests of that nature.
I think you could anticipate that, because we get a number of requests that we deny. And so I wouldn't want the board to come away thinking that if we made these changes, you would never see these coming back to you. And because I think they probably would.
I think to Kim's point, I think we're going to get an avalanche of them. Now, thinking in retrospect, right? How many cases are going to be out there about physicians, sexual misconduct, or whatever? And how is that any different than the Strauss case if it's one off? What are we going to say? Well, but that because they had critical mass and the other one only has 2 people or 1 person. I can see a situation, to Kim's point, where this could get a bit unwieldy, and I don't know, it's going to be a slippery slope. Once you open that door, how do you stop every other one that's coming through? Not that you necessarily want to, but I think it just raises the question, do we want to be doing that? Or do we want the process to kind of have some kind of parameters that we don't have to do that? I don't know. It's a difficult question.
Yeah, good cause and public safety are relative.
So we're talking about clarifying the statute about who is covered by an F5 confidentiality, i.e., at the end point, the SCUI, whatever the name of that firm is, I never remember the name, that we talk perhaps about some kind of discipline for the breach of that confidentiality to those who are not, at least to those who are contracted out, as opposed to the governmental entity itself. And then we're talking about, in addition to that, maybe a good cause exception, and how do we protect that? Are those the 3 issues we're dealing with? Am I summarizing that correctly?
I think so.
I think so.
So, Dr. Stottenstein, where are you on good cause?
So my initial thought was that if we're going to release for good cause, and again, the reason we're having this conversation is because we're talking about releasing to a non-F5 entity, because we can already release to an F5 entity. If we're talking about releasing for good cause to a non-F5 entity, my thought is that that's a substantial step, and that should require a full board participation and vote. But again, what could happen as we have continued our conversation is this could get unwieldy, because we could end up getting multiple requests from entities who feel like there is a legitimate good cause or public safety concern. And conceivably we could get inundated with this. Mm-hmm. So I guess that's my concern about opening the door as we're sitting here talking about it.
So if the pharmacy board has a good cause exception,
they do.
In between those might be. Again, I don't know if you want a complete door shut, which apparently we have right now. If you want to let the door open only if somebody knocks on it through the court process. There may be a way in between if you feel that the medical board needs to have some kind of process for good cause, that so we don't look completely. I can't even think of a circumstance in which it would be a good cause, but there's probably one out there. Maybe your in between stand is, look, you can knock on the door. We say no all the time. The only way you get open is you knock on the door through a sort of a court process as opposed to a board process. Mm-hmm. It's just a suggestion, but mm-hmm. And that puts it. But the problem when you do that is then you're starting to create you're letting it into an entity that is more political and less bound by the restrictions we have as a board. Angela,
sure.
May I just ask Angela a question? Angela, can you think of an exception? Can you think of a good cause exception rationale?
Not necessarily, but I can look at that. I think it's kind of that note when you see it type thing. And I guess I'm thinking of maybe some victim advocacy groups might be, entities that you might see that are not F5 entities, right? Asking for access that you wouldn't already be giving to law enforcement, right? I mean, I'm just sitting here trying to contemplate even what kind of entities we might be dealing with, that would be asking us for this, that aren't already F5 entities and already entitled to it. Mm-hmm. I was going to suggest in regards to the consequences for violating this, because I do agree that we need to have, in order to be able to enforce that confidentiality, have some consequence if that is breached by one of the entities that we do pass along the information to. And I know, for instance, in wiretap statutes, there is kind of that language. So you might want to look at that, Kim, as far as that. I can email you the exact statute, because again, that's just information that is treated highly confidential, and you're not even allowed to discuss the fact that there is a wiretap, right? Mm-hmm. So it provides some consequence if that is breached. So.
Great, thank you very much.
I would also, Betty, I agree, the suggestion of, knock on the door with a court process, then yes, you're kind of surrendering some of the control that I think maybe the board is better situated to make those determinations, I guess,
Mm-hmm. Right. And I will say we do receive a number of subpoenas, and for a criminal subpoena, we're pretty much always going to give up the information. For a criminal subpoena, for a civil subpoena, we don't, because of the language of the statute.
Dr. Favreau, you had a thought?
Yeah, I just think most of this, I agree with Angie that most of these are going to be covered by the F5, and this is almost a statute looking for a purpose. So I think we need to be very narrow in how we revise this. I think the board always has the ability to waive confidentiality in the right situation. And I think we would have waived confidentiality fairly quickly had we felt that the confidentiality of our victims and other stakeholders would have been respected by statute. So if we put that in the statute, I think that solves this problem. We have a full board vote. I mean, I don't think the good cause exemption is a difficult issue to me. And maybe I'm simplifying it too much, but I think we would have released it to Ohio State and everyone else if we felt that our information was definitely going to be kept confidential. And I think that was our big concern.
Can I ask one clarifying question? Because maybe I got this wrong and I haven't looked at F5 lately. But if we have a situation where you have just one person who's alleging that a doctor acted inappropriately, which could be for safety reasons, could be for sexual misconduct, whatever, could they come to us if we revise the statute like we're talking about here and ask us to give it up? And if so, what is our argument when we give it up to Ohio State when you have a plethora of people and you have one or two? I mean, what's the critical mass there that all of a sudden it triggers into, a public safety issue or, good cause? That's where I'm struggling a little bit with this, because allegations are allegations. Now I can get you, a handful of people, and getting to court's no big deal. File the complaint, we're in, you got a subpoena. So I just want to understand this. Is there a distinction here? Am I missing something? that wouldn't be triggered? Or could that be triggered? Because that makes a big difference in terms of the number coming through the door.
Right. I think you're raising a really good point. And what if a victim wants to use the medical board's investigation in litigation? Or what if the doctor wants to, we've seen that before, where a physician wants to use the fact that the medical board closed an investigation in litigation. So, both those issues.
This is where I struggle with. I mean, I think you can always make a good argument, especially if somebody's potentially hurt, to get this before us. And that's my concern is, how do we handle this? And when do we never say no at this point? Because it seems like it just gets it's going to be a slippery slope. Okay, well, here it was 500. Well, now it's 100. Well, now it's 50. Now it's 10. Now it's 5. Now it's 1. Where's the cutoff? And is there going to be a cutoff at all at the end anyways? And again, I'm not trying to, stop things, but I think we need to preserve the confidentiality aspect of this too, because that has a very important point in not chilling the information coming through the door too. So we don't want to go one way on the pendulum or the other and sacrifice both in the end. So that's my only concern here.
Mm-hmm.
Yeah, one patient, one victim could come forward and say, I want these records released to the public because it's for a good cause, because this doctor who perpetrated is actively practicing, right? And it's a public safety issue. And what would we say at that point?
That's where I think the board discretion comes in, and we as a 12-member board debate it and move on. And as they see that we're not going to willy-nilly release this, it has to be for a very good reason, like the Strauss situation. They'll stop requesting it. I mean, and it's something that can be done at a board meeting in a very quick manner if we have to. And if we find that we're inundated with it, then, we can ultimately have a expedited system for how we handle this at a board meeting. And I don't know what that is, but I don't think we're going to be inundated with requests once they realize that this is going to be the exception, not the rule. And we as a board need to just have that idea that this is an exception, not the rule. And I think everyone agreed that in the Strauss investigation, we should release this. We were just concerned about the confidentiality. So if we clear that part up, I don't think this is going to be as big a problem as everyone's making it out to be. I could be wrong, and maybe we'll be inundated, but I think quickly people will realize they're not going to waste their time inundating us with inappropriate requests that for one or two situations.
You have a lot more faith in the law profession than I do. I think that.
I was going to say, everybody feels like their own case is an exception.
Wow.
Yeah.
Because there's no downside.
Yeah.
I think we're going to be very.
I wish you were right.
Because
so for the sake of time, I would just recommend maybe that we take a stab at drafting this, and also again, as Kim mentioned, working with some of our other agency partners, because they have language that's similar, that could be impacted as well, and also working with the AAGs on this and really understanding the case law implications. But I do know, Kim, there's one more piece that you wanted to talk about with respect to the time limit on confidentiality. We have about 10 minutes left for our time here.
Right. And I think we're starting to touch on it in the conversation. The other thing I just want to throw out there, which is, kind of coming to my mind as we're having these discussions, you could easily have a situation where you have a request for information and it's an active investigation, information that would be coming before the board. The cases we brought to you previously were actions where it was all closed and the board had already done what it was going to do, and you waived your confidentiality in those kind of complete records that were already done. I think, just as I'm thinking about how to draft, I need to think about that as well, because what we don't want to do is, provide information to the board that would then taint you if a formal action comes before you later. So we may need to have like a designee process or something if it's an item that I want to share with you. And then moving on, there was a recommendation for a time limit on confidentiality. I think really to get to the point of, which I think is a valid point, that the board's processes, the board staff's actions with respect to investigations shouldn't be confidential and not under the kind of the oversight of the board, but identity of patients and, you know, and physicians and things should still be protected. So I started looking at what would be a reasonable time limit. And, you know, one thing I think about is, you know, the public records exception for confidential law enforcement investigative records, which typically, you know, the clears exception, typically, you know, like law enforcement records are public after the investigation is complete. About one of the things that I think is problematic for us is we may have complaints that are closed, you know, so we could have one individual who could have multiple complaints. Some complaints could be closed, some could be open. You know, how do you deal with that? And, you know, so that was kind of a question that I had. So basically, what is the starting point for the time frame if you were going to develop one? You know, is it the closure of an individual complaint? Is it the completion of an enforcement or a formal action, which is what's contemplated from the Strauss working group? But we know that the majority of the complaints don't go that way, that the majority of complaints don't even get to enforcement, and certainly don't get to formal action. So how do you deal with those? And then another thought I had, but I'm not sure this gets at what the group wants, is do you go from like lapse of a license? Like if a person's license has been inactive for a certain number of years, like in the Strauss case, you know, his license had been inactive, he was deceased. You know, I think that made some things a little bit easier for the board in that situation, because it wasn't an ongoing, you know, there weren't ongoing things that you were dealing with, and you weren't going to have a formal action coming forward. So, so I think that's a question I have. As I was doing this, kind of an idea I had, and it segues into some of the FSMB reports, is, you know, a way to make the board's investigative functions more transparent to the board itself for oversight. And so one thought that I had was to make some language change in F5 to allow like a committee or designee or group of board members be able to review confidential information, you know, after closure of complaints, to review for those purposes. And I thought that might be a way. It's a little different than what was suggested, but it might be a way to get at that, that goal, I think, of having more board oversight of, you know, kind of the actual, what happens in actual cases, you know, as kind of a post audit. So that was just an idea I would throw out.
So we used to have a quality assurance committee. You know, years ago, there were a few physicians who sat on it that would essentially audit the charts of cases that had come before the board. So I think that especially with the FSMB report, you know, that's something that I know Stephanie and I have talked about it. We've had some, you know, discussions about, you know, implementing something like that. Do you feel like we would need a language change to bring that back?
I think we would be in a much better position. I think you're still going to have to be very careful with that. It's sort of not to mix up the board's roles. You know, you don't want to do anything that is going to really, for lack of a better word, like to taint the board if an action comes before you. You know, that's a definite issue. But I think if we had the statutory authority if it wasn't a majority of the board, if it was a committee of the board and you had the statutory authority, I'd feel more comfortable with that.
Kimberly, Kim, can I just start with an assumption? Your assumption is that we don't, maybe what your last comment was clarifies what you were trying to say. I immediately was looking at the fact is, I think the board has a right to look at the investigative materials anytime, period. Now, whether it taints us is a question, but you weren't saying we didn't have the right to see it, the materials. You were saying you were concerned because it would taint. Okay. I think at some point we have to figure out an audit process, a postmortem. It helps. It helps us do an internal stuff. I agree with Dr. Schottenstein about that, and with you. And B, I am concerned. I continue to be concerned with the report's suggestions that certain investigations released at a certain time. For example, we do an investigation. We find this is an outright lie. Somehow we establish this is not true. We've got a physician or a licensee accused of X. We have clear evidence that X didn't happen.
Mm-hmm.
That investigation, I don't see why that investigation, I would hate to see that in 15 years, somebody can come in and smear somebody's reputation because of a retaliatory act taken on a position. So anyway, that's just.
No, I think that's a very valid concern. And I think on the flip side, we want people to report things to us. We really want other physicians and other licensees to report to us. And one of the ways that we are able to do that is to say, your identity won't be known. It will be confidential. And I think having a time limit, does create problems with that. You would have to say, yes, you can, it will be confidential for 5 years or, something like that. And I think that makes it more difficult to get the complaints, which we certainly want and need.
Yeah, so it could have a chilling effect, basically.
Mm-hmm.
Any downside other than the time commitment. But one thing I might suggest is it not be a permanent committee, that we have people rotate into that committee so we get a better diversity in terms of the opinions of the review, because you got to get maybe 3 people and they always see the same ones, and we get this kind of mindset. If you kind of rotate people periodically in there, we might get a bit of a diversity in terms of opinions on cases, perhaps. I don't know. I'm just throwing it out there.
Yeah, I think that's always a good idea. It certainly raises challenges for, our tracking ability to vote. But I do think that was certainly a theme that we've seen, is having diversity, having different people involved leads to a better product.
And my thought too was along those lines that it would, I think, make sense to always have a public member involved in that process. Mm-hmm. So, okay. I see that we're running up on 9 o'clock. Is there anything else that we needed to get to today? I know, Stephanie, you had the audit report, the color coded. Is there anything you wanted to speak to in that regard real quickly?
So I'll just highlight that for you. And then maybe if you want to follow up with me individually, this is sort of our plan of action. And then we can bring this back for more information in September. I think just really quickly to highlight on that chart, what we've done after receiving some staff feedback and having internal discussions, we've taken the FSMB report and broken it into all of the different steps that they've recommended. And then we have created this color-coded chart for you where we think, the green items are things that we've probably already been talking about, or we think maybe some low-hanging fruit or just some really obvious operational things that we can go forward with. The red are things that we do not recommend doing, at least in the forms stated by the FSMB report. The yellow items, we just need, I think, to have a little more board discussion that we can do in September, and we're looking at possible budget constraints, or even legislative challenges. So the yellows are a little trickier and need more discussion. And then the orange items are those items that I think, are the sort of the meatier topics that we would really want to bring forward to the retreat and wrap into some of the other things that we've been talking about for retreat themes as well. So for the sake of time, I think that really, if you could spend some time maybe over the next couple of days or a week, even looking at the green and the red, and just maybe reach out to me and communicate to me if you have any challenges with what we've presented. I'm happy to answer any questions right now. We are kind of running into policy committee, but it's okay. We can, answer questions now if need be.
Anybody? Okay. Thanks everybody for a nice discussion. Maybe if it's okay, we'll have a motion to adjourn.
Move to adjourn.
Ms. Montgomery and Mr. Jaglone. Let's say all in favor. Aye.
Aye.
All right. Thanks everybody. See you in policy.
Thanks.